Hello, dear aspirants. Welcome to Epitome IES. So, dear aspirants, we are doing the PYQ series. Today's topic would be judiciary from the Indian polity. Okay, let us start with the first question. Which of the following are included in the original jurisdiction of the Supreme Court? 1. A dispute between the Government of India and one or more states. 2. A dispute regarding elections to either house of the parliament or that of a legislature of a state. 3. A dispute between Government of India and the Union Territory. 4. A dispute between two or more states. So, in this question, they are asking about the original jurisdiction of the Supreme Court of India. Okay, one of the previous question we actually saw about this original jurisdiction of the Supreme Court of India. And if you see here in the first statement, they are saying that a dispute between a government of India and one or more state. Yes, this is directly comes under the original jurisdiction of the Supreme Court of India. And if you see the fourth statement, they are saying that a dispute between two or more states. Yes, whenever there is a dispute between two or more states, then also this particular disputes will be coming under the original jurisdiction of the Supreme Court of India. So we can directly say 1 and 4 are there. See the options. 1 and 4. 1 and 4 is only there in the option C. So we directly got the answer. Okay. So even though you don't know about the statement 2 or statement 3, you are confused whether it is there or it is not there. With pre-existing knowledge, you should be able to eliminate or you should be able to get the answer. Okay. So if you see here, statement 2 says that a dispute regarding elections to either house of parliament or the state legislature. No, this does not come under the original jurisdiction of the Supreme Court of India. We'll be reading some 4-5 cases where the original jurisdiction of Supreme Court will be there. So this is not one of them. We can eliminate this. And if you see statement 3, a dispute between Government of India and Union Territory. So whenever we are reading about this original jurisdiction, we'll be reading about the disputes between union, that is central government, and the states of India. Okay, one or more states. But we never read about the dispute between the union, that is the government of India, versus the union territory. So whenever there is a dispute between government of India and the union territory, there'll be through executive actions they'll be trying to resolve those issues, and this does not come under the original jurisdiction of the Supreme Court. So we can eliminate this as well. So 1 and 4, option C is the correct answer. So if you see here, this is the original jurisdiction of the Supreme Court of India. This comes under Article 131 of the Indian Constitution. You have to remember this. So under the Article 131 of Indian Constitution, it talks about the original jurisdiction of the Supreme Court of India. So we'll be seeing what are these original jurisdiction which are given to the Supreme Court of India. First would be whenever there is a dispute between the Government of India, we can say Union, okay, Indian Union. We can also say the Government of India. Here we are referring to the central government of India. Okay, so whenever there is a dispute between the Government of India versus one or more states. Okay, whenever there is a dispute between Government of India versus one or more states, these disputes comes under the original jurisdiction of the Supreme Court of India. And there is a second case where there is a dispute between the Government of India together with any state, let's say one or more state, versus other one or more states. Can you understand this? Whenever there is a dispute between the Government of India together with some other states versus some other state. You should see this versus. Versus means this versus this. So the dispute is between this and this. Okay. So in this case, second case, the Government of India is supported by one state or two states also, and this is against some other states. Okay. This also comes under the original jurisdiction of the Supreme Court of India. And there is another case, that is the one which we saw in the question itself, statement 4. That is whenever the dispute is between two or more states. Okay, whenever there is, let's say, there is a dispute between Tamil Nadu and Andhra Pradesh, so this will come under the original jurisdiction of the Supreme Court of India. Okay, it can be more than two states also. Okay, so this is another point. Then we have, whenever there is a enforcement of fundamental rights. Okay, and during the enforcement of the fundamental right, there is some sort of a confusion, there is some sort of a dispute, then this also comes under the original jurisdiction of the Supreme Court of India. We'll be talking about Article 32 here. What does Article 32 provides in the Constitution of India? They provides for the writs. Tell me, what are these five types of writs which are given by the Article 32 of the Indian Constitution. So for enforcement of the fundamental right also, this directly comes under the original jurisdiction of the Supreme Court of India. Then the fifth point would be, let us say the Supreme Court has the power to transfer cases from one high court to another high court. This is high court. Okay, so whenever there is a case pending in a high court of a particular state, this Supreme Court of India has the power to transfer this case to some other high court of some other state. Okay, this also comes under the original jurisdiction of the Supreme Court of India. There is one other point we can say, the Supreme Court also has the power to transfer the cases which are pending in the subordinate courts. Okay, this case is pending in the subordinate courts, are also can be transferred to any other high court from other state also by the Supreme Court of India. Okay, these are the original jurisdictions of the Supreme Court of India. You can take a screenshot of it. So then we'll move on to the next question. Consider the following statements. The Supreme Court of India tenders advice to the President of India on matters of law or fact. What is this? This is nothing but the advisory jurisdiction. Okay. So statement 1 says that on its own initiative, on any matter of larger public interest. Statement 2, if he seeks such an advice. Statement 3, only if the matters relate to the fundamental rights of the citizens of India. So whenever we read about this advisory jurisdiction, we'll be reading about this, that whenever the President of India, he seeks for an advice, then only they'll be rendering this particular advice on any legal matter. Okay, the first statement says this will be done on the own initiative by the Supreme Court of India. No, this is wrong. They cannot, they cannot give the advice on their own. Okay, they'll be giving advice on the after the President asks for it. Okay, then if you see statement 2, if he seeks such an advice, yes, whenever the President of India is seeking for an advice, then only they'll be giving the advice. This is there. So 1 is eliminated, this is gone, D is gone, 2 is there. So if you see, only B has 2, option B is the correct answer. And if you see 3, only if the matters relate to the fundamental rights of the citizens. Technically, this advisory jurisdiction not necessarily, it only contains the fundamental rights. It contains like a larger amount of things, provisions. Whenever this President has a doubt regarding any legal matter, regarding the Constitution, this particular Supreme Court has the power to give that particular advice. Okay, so this particular statement is a wrong statement. Answer is B, option B, answer 2 only. So advisory jurisdiction of the Supreme Court of India, this is actually mentioned in Article 143 of the Indian Constitution. Okay, it simply says that whenever the matters which are referred to by the President of India, whenever the President of India is seeking any advice from the Supreme Court of India, then only the Supreme Court of India will be rendering those advices. Okay, it can't go and render the advice on its own. Okay, simple. Then with reference to the Lok Adalats, which of the following statements is correct? Option A, Lok Adalat have the jurisdiction to settle the matters at pre-litigation stage and not those matters pending before any court. Option D, Lok Adalats can deal with matters which are civil and not criminal in nature. Statement C, every Lok Adalat consists of either serving or retired judge or judicial officers and not any other person. Option D, none of the statements given above is a correct statement. So they are talking about this Lok Adalats here, and statement 1 is saying that Lok Adalat have the jurisdiction to settle the matters at the pre-litigation stage. First of all, what is this pre-litigation stage? Pre-litigation stage is nothing but whenever there is a dispute or any other cases which does not come under the court. Okay, before getting in the court, this particular stage is called as a pre-litigation stage. Okay, once it has come under the court, okay, this particular case, then they'll call it as a litigation stage. So what they are saying in this particular statement is Lok Adalat have the jurisdiction over the cases which are in pre-litigation stage, that is before reaching the court itself. Okay, and not those matters pending before any court. So technically, Lok Adalats have jurisdiction over both these things, okay? Both the pre-litigation cases and also the litigation cases. The cases which are already pending under any court, this can also be taken up by the Lok Adalat. The only condition is it should be somewhat, minor and petty cases. There are some, cases, there are some types of cases which are already mentioned. Only those type of cases can be taken up by the Lok Adalat, not those cases which are very legally complicated. Okay, so this particular statement is a wrong statement. Why? Because Lok Adalat can also take up the cases which are already pending in the any court. Okay, so why this particular provision is there? First of all, Lok Adalats is one of the alternate dispute resolution. Okay, last video, in one of the last video, we were talking about the Gram Nyayalayas. Okay, so this is also one of Lok Adalat, is also one of the alternate dispute resolution. So when large number of cases are pending in the courts, high courts and subordinate courts, so to reduce these number of cases by amicable, okay, by compromise, for this particular thing has been established. And here what they are doing, those cases which are already in pending in courts, along with the pre-litigation stage, which can be easily solved by compromise of both the parties, these are taken up by the Lok Adalat. Okay, so this statement is a wrong statement. If you see option B, Lok Adalat can deal with matters which are civil and not criminal. So technically, Lok Adalats can also, take up the matters, both civil matters and the criminal matters. There is no restriction that it should take up only the civil cases and not the criminal cases. If you see, majority of the cases are civil cases. But yes, there are some cases which are actually criminal cases which can be taken up by the Lok Adalat. Okay, so we can eliminate this option because it's a wrong option. Okay, then every Lok Adalat consists of either serving or retired judicial officers and not any other person. So if you see, whenever the composition of the Lok Adalat, there will be approximately 3 members in the Lok Adalat. The bench consists of 3 members. So the first one would be, obviously the first two would be relating to the serving or retired judge. Okay. But the the third one would be any other person. Let us say some person is doing some sort of a social service. Okay. He's having some experience in that particular field. So this particular person is also included in this particular bench. Okay. So what they're saying, only the retired or the serving judges are included in the bench and not any other person. This is wrong. Why? Because other persons are also included, not necessarily the retired judge or the serving judge. Okay, so this is wrong. Option D, none of the statements given above is correct. Yes, this is the correct answer. Option D is the correct answer. Why? Because all the options given above are wrong. Okay, then so these are the type of cases which are handled by the Lok Adalat. Okay, Lok Adalats can deal with wide range of civil matters. Where mostly they'll be dealing with civil matters, but also some of the criminal matters they'll be dealing. So what are these examples we can see? One is bank loan recovery disputes. Okay, then we have family disputes, property disputes, labor disputes, accident compensation claims, etc. Okay, but it also deals with the criminal cases. For example, we can say the compoundable criminal cases. So this is a key term which you have to notice here. Compoundable criminal offenses. What is this compoundable criminal offenses? Okay, we have compoundable criminal offenses and we have non-compoundable criminal offenses. So you have to understand what is this compoundable criminal offenses. These are the criminal offenses where whenever there is a two party, let us say these two party are having some sort of a dispute. Okay, this is a criminal case, and in this case there is a possibility that these two parties can compromise. Okay, through compromise, and let us say one party has got affected because of this particular case, because of this particular act, then this particular victim or the particular person who has got affected, he'll be given some sort of a compensation by the opposite party. So through compensation, through compromise, this particular case will be solved amicably. Okay, so these are the criminal cases which are compoundable, that is which can be solved by compromise. Okay, these are compoundable. And for example, we can say trespassing, and we can say adultery. So there are different examples. So in these type of cases, there will be some sort of compromise which will be happening between both the parties, and they'll be amicably solving this issue. Okay. So these are non-compoundable, these are compoundable criminal offenses, and there are non-compoundable criminal offenses. What are these? These are the criminal cases which cannot be solved by the compromise of the two parties. Let us say one party has done a murder or a kidnap. Okay, then even though he'll give compensation to the victim or anything, it can't, it is not fair, right? So this particular case is called as a compoundable criminal offense. Okay, sorry, non-compoundable criminal offense, which is not able to compound, that is it cannot be solved through compensation. This particular person who has done this particular crime, he'll be punished according to the law. Okay, so the Lok Adalat, they can take up the criminal cases. Okay, they can also take up the criminal cases, only those criminal cases which are compoundable in nature. Okay, for example, we can say these are some minor offenses where the aggrieved party can choose to settle the matter outside the court itself. Okay, through compromise. So this is there. Then composition of Lok Adalat. So as I already told you, the Lok Adalat has mainly three members. Okay, we'll be seeing about it. A Lok Adalat bench typically consists of three members. A chairman. Okay, first member would be the chairman of this particular Lok Adalat, who is a retired or a serving judicial officer. He can either be a retired officer, judicial officer, or a serving judicial officer. He'll be the chairman, and other member would be usually a lawyer. Okay, lawyer offering legal guidance during the settlement process, and the third member would actually be a social worker or an expert in specific field of that dispute. Okay, let us say this particular dispute is related to any particular topic, and this particular social worker or he's an expert on that particular topic, then he'll be included as a member. Okay, so that is the thing. Next question, consider the following statements. Statement 1, the Advocate General of a state in India is appointed by the President of India upon the recommendation of the governor of the concerned state. Statement 2, as provided in the Civil Procedure Code, high courts have original appellate advisory jurisdiction at the state level. So if you see here in the statement 1, they are saying that the Advocate General of a state is appointed by the President of India upon the recommendation of the governor of the state. So whenever we read about this Advocate General of a state, we clearly it is mentioned that he is appointed by the governor of that particular state. Here nowhere this President of India is seen. So this statement is a wrong statement. And if you see statement 2, as provided in the Civil Procedure Code, high courts have original appellate advisory jurisdiction at the state level. So technically this civil procedure code does not talk about, the jurisdiction of the high courts of India. Okay, these jurisdictions are directly talked by the Constitution of India, not the civil procedure code. See, we can eliminate this option as well. So the answer would be option D, neither one and nor two. Advocate General of a state. So we'll be reading, somewhat about the Advocate General of the state. So this particular Advocate General of a state is a constitutional position. First thing we have to remember is whenever there is a post which is given, you have to remember whether it is a constitutional post or a non-constitutional post. This is a constitutional post. Why? Because it is directly mentioned in the Constitution of India under Article 165 of the Indian Constitution. So first point you have to remember is Advocate General of a state is a constitutional post. Okay, he is the highest law officer of a state. Okay, this Advocate General of a state is also known as the highest law officer of that particular state. Now tell me, who is the highest law officer of the country? Okay, tell me that. Then this Advocate General of a state is responsible for advising the state government on legal matters referred to him by the governor. So what is the major function? First function of this particular Advocate General of India? He is responsible for advising the state government on the recommendation of the governor of that particular state. Okay, the Advocate General of a state is appointed by the governor. So this is what you have to remember. Who appoints the Advocate General of a state? This Advocate General of a state is appointed by the governor of that particular state. There is no mention of a president. Okay, then he serves at the governor's discretion and receives such compensation as the governor determines. So what they are saying is, this particular Advocate General of a state, he will be holding the office during the pleasure of the governor. What it means? There is no tenure which is directly mentioned in the Constitution of India. There is no term of office. Instead, what they have given is the governor decides, okay, whichever term he is going to serve. And also the compensation is, let us say, salary. Okay, this is also given, or it is also determined by the governor of the particular state. Okay, not by the Constitution of India. These two things you have to remember. The Constitution of India does not provide for any term for the Advocate General of a state, and it does not provide for the compensation also. It clearly said that it is on the governor's discretion. Okay, remember this. Then the qualification of an Advocate General of a state. So what are the qualification? First is he must be a citizen of India. Okay, if he is a foreigner, he is not eligible for the appointment as a Advocate General of a state. He must be a citizen of India. Okay, the person must have been an advocate of an high court for at least 10 years. Remember this. Okay, what is the qualification? The qualification is the Advocate of General of India, Advocate General of State, Advocate General of State. The qualification is he should actually serve as an advocate of an high court for at least 10 years. Remember this, 10 years. Or else there is another condition, that is if he is serving two or more such courts in a succession. Okay, he can also serve two or more succession courts also. Okay, but basically he should be serving as an advocate of an high court for at least 10 years. Okay, the person must have held judicial office in India for at least 10 years. So he should be, holding a judicial office in India for at least 10 years. So these are the qualifications for Advocate General of a state. So next question, with reference to the Lok Adalat, consider the following statements. Statement 1, an award made by the Lok Adalat is deemed to be a decree of civil court and no appeal lies against it before any court. Statement 2, matrimonial family disputes are not covered under the Lok Adalat. So here again we are talking about the Lok Adalat. Statement 1 says that an award made by the Lok Adalat is deemed to be a decree of civil court. Yes, this is deemed to be a decree of civil court. This part of a statement is correct. And no appeal lies against it before any court. Yes, again, there is no appeal which is available for the decree or the judgment of the Lok Adalat. This is correct. Okay. So whatever the decision the Lok Adalats comes up with, the parties are binding to take up that particular, decision. Okay, there is no appeal for this particular thing. And statement 2 says that matrimonial and family disputes are not covered under the Lok Adalat. So if you see, we actually saw this, right? Majority of the cases are civil cases, and that in that matrimonial cases and family disputes are also taken up by the Lok Adalat. So this particular statement is a wrong statement. So answer would be option A. Only one is the correct answer. Okay. So that's all with today's class. We'll be seeing in the next class. Thank you, students.